Okay, everyone, welcome back to okay, we'll just give it a minute. Councillor Illingworth, you need to come back. Hello, good afternoon and welcome back to part 2 of the Planning Placemaking Committee on Wednesday, the 12th of March 2025. I'll ask the clerk just to confirm the presence of people online.
Afternoon. We now have Councillor Frampton in the chambers, so the only person online will be Councillor James. If you could let us know that you're there.
Still wide awake.
Thank you.
Thank you.
Okay, thank you. Before we broke for dinner, we were doing the application for the retail unit at Crieff Road. We are now on if members have any questions for officers. Councillor Allen.
Thank you, convener. Yes, just when the officers were talking about the application, there was a suggestion that there was an objector, and that was from Tesco's, but it was a late objection. Does that therefore mean that the objection is irrelevant?
No, all it simply means is that it would not count towards it being referred to committee, or that it would be published on the council's website, but any material factors therein would require to be taken account of.
Thank you. Can I just point out to you, Councillor Allen, you're actually in the wrong chat. You need to go to join another chat. Okay. Councillor Harvey.
Thank you, convener. The question I had is, I've actually probably got two questions, but I'll ask the first one first, and depending on your answer. Just the history of this site is related to the usage of this site. So in 2015, it was a residential and retail development. And then November 2015, residential and retail, and then it switched to just a residential development. So that was the last kind of before all this type of work happened. So the introduction of the retail part, is that an addition, or is that a change from the 2019 position?
So the position at present is it's a purely housing site. It's allocated as 871 within the local plan. Previously, historically, there was a planning application which came in for a housing and retail-led development. That application was ultimately withdrawn and not progressed. Obviously, there was a number of factors there in terms of the road connection at the crematorium road that came into play around that time as well. But certainly, the 2019 plan has it solely allocated for housing.
Thank you. You want to come back? Yep, no problem.
So therefore, just while I'm on the subject then, so this development's a relatively small retail development. So basically, any retail development would have been not allowed on that area, or is this because the applicant? Sorry, I'm not answered the question correctly. One of the applicant's statement was about the size of the development. It was within a reasonable size. Would any retail development on that site cause you problems from the planning perspective, or is it, or and therefore should it just be housing on that development? Thanks.
I'll take a deep intake of breath first. Yeah, it's there's a kind of twofold element. First and foremost, obviously, you've referred there to it, the scale of development. As far as we are concerned, this is not small scale retail. It's 1,949 gross internal square meters. It's a sizable store. From the perspective of whether or not any size of retail would be available, Policy 28 is very clear in outlining of MPF4 the scenarios at which we would consider retail proposals. So first and foremost, it's town centre first. You're looking at the edge of centre sites thereafter, and then basically it says proposals out with those locations will not be supported unless they are for small scale neighbourhood retail development. Now, we, through the Perth and Kinross Retail Study 2023, have indicated, and this is within the report as well, that small scale neighbourhood centres would be 500 square metres at maximum, with any individual unit not exceeding 200 square metres. Now, obviously, what's being proposed is significantly greater than that. If something was to come forward on that basis, something a lot smaller, it might be something that we could have looked at, but obviously we're assessing a much larger store here today, upon which is allocated for housing.
Thank you. Councillor Drysdale.
Thank you, convener. Yeah, my question, I've got another question later on as well, but my question for the moment is on a similar theme in terms of the retail aspect. Within the first reason for refusal, there's a quote that says that there is no requirement for an additional retail store, and the 2023 retail study report has been cited. Conversely, we've heard from the deputation today about overtrading, which Councillor Harvey explored further, and on the face of it, also from the Tulloch deputation and the written deputation from Bertha Park community and Latham for All and Councillor Rebeck, that there does appear to be demand, and so I guess my question is, do you stand by the assertion that there is no requirement for an additional, and I'll just add the words here, discount food retail store on that site?
Thank you. I think the question here is identified demand via the retail study relative to the available spend in catchment areas, and in relation to that, there is no identified need for additional provision to be made relative to the details set out in the retail study. I absolutely accept that there is local perceived need and demand and preference for an additional store. I'd maybe pick up as well on the price point comparison, that is not a material planning consideration in terms of retail policy analysis. So whether it was the applicant that's providing there and there's a perception that they have a more price point positive offering to others, or any other proponent of a retail proposal there of that scale. In fact, anybody could occupy that store, whether it be a high price point or a low price point. There's no differentiation. So I think the point that's being made within the report relates to identified, substantiated, data-based need against established methodologies for determining whether or not there is a requirement to provide additional floor space for retail proposals rather than perceived need.
If I may, just a follow-up to that, convener. So can it just be clear, we talk in the one breath about town centre first, and in another breath about 20-minute neighbourhoods, and I'm just wondering which has primacy?
I think, again, things need to be looked at in balance. So when you're talking about the first point was need, but the second point, 20-minute neighbourhoods, again, we have a number of offerings as set out in the report in terms of retail floor space within that neighbourhood. Again, I accept that, you know, there is a perception and perhaps a reality that some of them are not seen as being as value related in terms of their offering as others, but there are a number of offerings within 20 minutes walk from the communities which this proposal would be cited within.
And Mr. Fogg would like to come in on this.
Yeah, I think listening to Councillor Drysdale's question there, I would be perhaps more robust and say that in terms of policy 28 of NPF4, which I have in front of me, it does seem to put primacy at the town centre first, because it does say development proposals for retail will be consistent with the town centre first principle. So that's the first thing stated in the policy. It then does go on. There is provision for local neighbourhoods, but the restriction applying there is the size indication that Mr. Williamson said of not in excess of a total of 500 square metres and no one being more than 200. So that's if you get into the local neighbourhood, it's then envisaging something of a very much smaller scale than the current proposal. And that's the problem, and why I think the applicant's agent had to concede it's not in accordance with NPF 4 policy 28.
Okay, thank you. Councillor Braun, let you answer your first question.
Yeah, thanks, Convener. I've got several questions, but if I can just clarify, it seems a simple question, but I'll just clarify this one. LDP and NPF 4 statutory guidance, but my understanding is we can depart from that if we have sufficient material considerations to do so. Am I right in that understanding? Mr. Fox just asked that, saved your job. Yeah. Thank you.
Councillor James.
Thank you, Convener. Actually, what Councillor Braun's just said there, I'm sort of further to that. We're sort of bound up by policy, and common sense sort of goes out of the window. But then the policy, as its guidance, you can read it one of a couple of ways, and I'm seeing policy 28, which is the big one, is something different, because if you have NPF 4 policy 28 open, the policy intent is to encourage, promote, facilitate retail investment to the most sustainable locations that are most accessible by a range of sustainable transport modes. That's the intent. So would you agree that this site actually fits into that category, but then the policy then goes on to comes up with contradictory information? Thank you.
Thank you, Councillor James. Yes, I do accept the wording of the policy intent introduction of policy 28. However, the devil is in the detail of policy 28 itself. And when you consider it against the various criteria within that, then it just simply doesn't comply with it.
Councillor Illingworth.
Thank you. Can you explain why this site is considered out of town? Because it's right in the heart of Tulloch, right in the heart of Latham, and there's lots of other housing out just by Dobbies. Thank you.
The local development plan itself sets out what the defined town centre is, the edge of centre sites and the commercial centres, and this is not within one of those allocations.
Thank you for that. Councillor Cuthbert.
Thank you, Convener. Yeah, I'm trying to get my head around all these rules and regulations with regard to food stores and so on. We've just been told that Tesco's is over trading. I'm just wondering if they are over trading and they sought to expand the size of their store by, say, 1900 square meters, would that be approved, or is it because it's a pre-existing site, or how does it work?
In that instance, obviously, that's not necessarily what we're faced with today. Obviously, we're assessing the application on its own merits. We wouldn't need to look into the detail of that if an application were to come forward. But there's probably differences with that site, but what I would say at the same time is that while there may be instances where there's over trading, there's also instances where there's under trading at other existing stores as well.
Can I address that to the clerk? Because it's more of a legal question than a planning question, if you like. I'm just trying to get my head around how this works. So if a store that pre-exists puts an application to expand, despite it not being in the town centre, would that get consent?
It's not possible to take an abstract proposition saying yes, the outcome would be approval or not. It would very much depend on the facts and circumstances of that application. I think it impossible to conceive that an extension of the scale of 1900 square meters gross would be acceptable. I think at that scale, I would be expecting it would have a very difficult time getting approval. If it was something much less, then possibly.
Sorry, but maybe just to give some context as well. So the store that you refer to is within an identified centre, but we would still need to look at what the retail impact was of such a significant additional floor space offering. But as Mr. Fogg says, you know, can't look at it in absolutes. We need to look at the devil in the detail, but there are quite considerable differences in terms of the matters that would need to be considered there. That is an identified centre. The site that we're talking about here is not.
Thank you. Councillor Braun.
Thanks, convener. It's a question for Mr. Fogg, I'm afraid, this one. When we were discussing the case with the agents for Lidl's, we referred back to this judicial review. Now, my understanding was, as we discussed it, was that when the judicial review came up last time around, it was successful, because when we had approved that particular application with Aldi, we had said it was within policy, as my understanding. I might be wording it slightly wrong, but my point is, in this instance, if it was to be approved, we would be saying it's completely outside of policy. So would that claim still apply? I probably haven't worded it very well legally, but hopefully you've got the gist of what I'm trying to work on.
Yeah. I understand where you're coming from, and you're right. In the all-day challenge for the Petevlis site, we were inviting the court to accept that the officers and committee were justified in viewing that proposal as being in accordance with policy 28, and the court said no, that wasn't a tenable position for different reasons. We were wrong, and it should have been viewed as in breach of that policy. In this instance, the clarification in the answer that was given by the agent this morning was they concede at the onset that it is contrary to. It means, therefore, that if it were to be proved contrary to the development plan, the committee would have to be satisfied that the weight of the other planning considerations was such that it justified an approval contrary to the statutory development plan.
So if that was the case, would a competitor have that same grounds to? They wouldn't have the same grounds they had before, is what I'm trying to get to. Is that correct?
If the committee, I don't see how the committee could do otherwise than acknowledge what the applicants themselves have said. This does not comply with policy 28. So there's no debate about that. What the committee needs to be mindful of is that the presumption in planning is that there's primacy is afforded to the development plan. So when I began 100 years ago, all considerations were equal, including the development plan versus everything else. We moved away in the mid-90s because as a result of revised legislation was brought in at that time, primacy was given to the development plan. So you need to have clear, cut and compelling reasons to justify departing from it.
Thank you. Go to Councillor Drysdale.
Thank you again, convener. The local press has picked up on issues around car parking around McDermott Park and on the occasion of football matches. I don't see any reference to that point in the proposed reasons for refusal. I may have missed it, but I don't think it's there. So I'm just seeking clarification on what officers' views are on the adequacy of parking, and if the site were to proceed, and what impact that might have on football traffic.
Thank you very much, Councillor Drysdale. From the perspective of what's tabled in terms of the car parking levels, it's maximum standards that they're looking to deliver on the site in this instance. The application has also been the subject of detailed review of transportation information, and I'm happy for Lachlan to come in on this as well. Obviously, there's a requirement for a signalised junction to go on onto the Crieff Road. That has then been demonstrated to be to a standard that is satisfactory in terms of its associated impact on the local road network. So from that perspective, that's a technical aspect which can be adequately controlled via condition. But I'm happy for Lachlan to come in further.
Thanks, Paul, and thank you for the question. Yeah, I mean, in terms of the parking standards that Lidl are proposing to provide, they are within the National Roads Development Guide that they are providing there, and they're also looking to further provide EV charging parking spaces there as well. Not only that, we've got our cycle parking on site as well for anyone who may want to cycle to the site, and we've also got bus stops nearby to encourage sustainable travel to the site. So whilst the parking levels are acceptable, there are other ways and means to get to the store. With regard to the football traffic, in terms of what Paul has already mentioned, we would be looking to condition the delivery of traffic signals for the junction in terms of access to Lidl itself and the wider housing scheme that's proposed there, should that come forward in the future. With that, we will need to seek that these signals are integrated into the Scoot system that we currently operate in that location. That was subject to a number of discussions with the applicant and going backwards and forwards. And I think we've got ourselves to a position that we're just about happy, subject to finalised design coming forward. So there are aspects that we still need to get details on, but I think we could sufficiently condition that, as Paul has already mentioned. Thank you.
Thank you for that. Councillor James.
Thanks again, convener. And mine's really a clarifying issue, clarity, because it says proposed. I'm harping on again about NPF 28, where it says proposals for small scale neighbourhood development will be supported if it can be demonstrated, blah, blah, blah. Bearing in mind that we've had a massive housing development go up in Bertha Park. We've got Hunting Tower, which has another huge development, and we've got the Almond Valley, which is, just starting to develop. So huge amount of houses in this area. Is this small scale of this application on a floor space or a scale within the community? Because I think the community deserves something bigger than what they actually have. Thank you.
Yeah, just to come back on that and appreciating the kind of question marks over the small scale retail element. I think one of the acknowledgements we would have first and foremost is that I don't think we've necessarily been helped by the Scottish Government's lack of definition of what small scale development is. Obviously, though, we have had the Perth and Kinross retail study, which has identified the figures, which have been contested by the applicant in respect of what we deem small scale retailing to be. Clearly, you mentioned a number of other sites such as Bertha Park, Almond Valley, etc. They all have individual small stores at present, either at present or coming forward. So I think Bertha Park's got Premier stores, operates out of there. There's certainly going to be more coming forward in the sites that have been allocated, whether that be Perth West. But at the same time, you know, as alluded to within the report, there are a number of existing retail outlets within the vicinity and within relatively close travel distance to the sites and these areas at Tulloch and Letham, for example.
Thank you. Councillor Braun.
Thanks, convener. There's another question for Mr. Fogg. I'm sorry. Paragraph 91 talks about another store which I believe Lidl's have opened in Livingstone, which was classed as small scale. I'm assuming that Lidl's don't build anything of small square footage. I mean, should have asked, I suppose, but I didn't. At the time that was approved, I presume, would that particular local authority have been aware of the judicial review that came up in ours?
Afraid I can't answer that, Councillor Braun, because I don't know quite when the timeline and which preceded. I have had the opportunity to read the West Lothian decision that's been referred to at paragraph 91. There, I noted it was accepted by the case officer that the Aldi store was not small scale, but I be careful what I say. I'm surprised. I think not all planning professionals would have agreed with that officer that the policy did comply with policy 28. More significantly, nobody chose to challenge it. Had they done so, it might have been a different situation. So I think I would be wary of putting too much reliance on that other decision.
So, could I supplementary on that? Sorry, could I then reverse that? If there was subsequently a judicial, I can't even say the word, judicial review for a competitor here, would that now carry weight? I don't want to use the word precedent because I'm not sure. The fact that it's been passed there, would that have some sort of influence on a decision, do you think?
Very, very limited. There was no judicial consideration of the decision, so there wouldn't be. It hasn't added to case law. There's no precedent before the court. It's simply an example of a particular planning decision taken in a particular case. I suspect there have been many other retailing decisions over the last 3-4 years that one could also point to that were different. That one happens to be reasonably recent where it was granted.
Thank you. Councillor Drysdale, your further question?
The questions keep coming up in my mind. So can I just check from the responses that we've received in the last few minutes, is it the case that in terms of national planning framework and any Scottish Government additional guidance there may be, that there is no definition of the word small in terms of retail? Is that correct?
Whether there is or not, I think the most important point that the committee needs to be aware of is wherever it may be, it's going to be a lot below 1,900 square metres that we have before us today. I don't think anyone can try to suggest that this proposal would be an example of small scale retail development. But maybe someone who's more familiar with NPF4 can offer an additional view.
The simple answer is no, but the maybe more informed answer would be, well, the judicial review associated with Heapless gave quite clear direction on that, and I think we've set out the detail of that in the report. So I think there was quite strong terms used by the judge in that case.
Thank you. Councillor Harvey.
Yeah, thanks, convener. My question concerns the reason number 4, or soon to be reason number 3 for reducing it. Is my interpretation of this correct? Is that you're feeling the salami slicing and comments related to that is that this development will just happen on its own and the housing will probably not follow on in future? Or is this related to more the design of the building itself, that the kind of comments within that section? Thanks.
I think there, obviously, we want to see sites that are allocated in a local development plan delivered for that purpose. Obviously, as I alluded to within my presentation, we are also in the midst of a housing crisis. We want to see sites delivered for the purposes that they're allocated for. The concern that we have in this instance is that the delivery of the site, and obviously the applicants have alluded to it today, they're taking up 30% of the site. They have identified that there is the potential to deliver the numbers that were identified within the local plan, but you are then looking at what is left over on the site. What are the site-specific circumstances as to, you know, how good will the delivery of that site ultimately be, given that you have or could have a retail development front and centre at the top part of the site, you know, in terms of considering good placemaking. You've got a yard area that sits at a higher level than the housing that would then sit beneath it, appreciating what they've said about putting in landscaping and a green bund and retaining feature. There are too many unknowns there for us at present in terms of what the delivery of this site, the implications would have on the delivery of housing thereafter, in that you're then left with 2/3 of a site sandwiched between a retail store and a football stadium, and whether or not that's ultimately going to lead to a good quality place thereafter.
So just to summarise, you kind of your fear would be that if this is developed, then the houses maybe wouldn't be developed, or it would be to be difficulties in that development.
It could certainly have implications that we would prefer to consider all at one time and have catered for through a phasing programme.
Thank you, Councillor Allen.
Thank you, convener. At reasons for refusal at number 1, it finishes off by saying the proposal would also encourage diversion of existing footfall and spend away from the city centre, and therefore would impact significantly on the viability and vitality of the city centre and local centres. My own understanding of all of this is that the local communities of Letham, Tullach, Bertha Park, Methven, Hunting Tower and Inveralmond, they're looking for an opportunity to spend their money somewhere other than in Tesco's. This has got nothing to do with them going into the town to visit a retail shop. This is about... my question really is, do we really believe that this is going to have a significant impact on the city centre?
I would hope you were able to acknowledge, Councillor Allen. Obviously, it does then go on to say about the impact on the city centre and other local centres. So it's not just about the city centre itself, but it's about the other established and identified commercial centres that we have in the local plan. And as alluded to, we've already identified within the report that there are a number of other retail stores, in addition to the one that's closest to the site, where there's access to other shopping, pricing structures, etc.
Thank you, Councillor Illingworth.
Thank you. What if this committee were to approve this development, what risks would the council face in terms of legal action against us?
Any person who is aggrieved with a decision of the planning authority has the right to apply for a judicial review of that decision. I think it is highly probable that there will be an aggrieved party who would challenge a decision of this committee to grant, contrary to the recommendation in the report of handling. What would that would then entail proceedings being commenced, and the council would then be required to either defend its decision in court or not defend it if the advice available to it was that it was not in a position to defend the action. If that was a situation in which the council found itself, the decision would be quashed and it would be remitted back to the council committee to retake the decision. And my honest view is that that is a highly probable situation.
Thank you. Councillor Braun.
Thanks, Gabriel. We're following on from this a little bit. The objection from a competitor, Tesco's, I might as well mention them, was late and therefore it's not recorded as such. Well, it's there, but it's not recorded. I don't know, it might be Mr. Williamson, Mr. Foff. The fact that it's not there, would that weaken their case if they wanted to do a judicial review? They haven't objected to it this time around.
No, they would not forfeit their ability to challenge the decision because they didn't respond within the statutory 14 days or whenever it's now allowed for a response to be submitted.
Just to clarify, they have objected. They have just not objected within, as Mr. Fogg says, a particular time frame. But whether they object this morning before the application's considered, or a number of weeks ago, or within the time frame, that we must still take account of the matters raised.
Okay, thank you. Any further questions? Councillor Drysdale.
Thank you. Yeah, it's just further to Mr. Fogg's response to the most recent questions. It is disappointing that Tesco, with such skin in the game, did not have the ability to respond within the time frame that everybody else has done. I have to note that, and therefore we are not able to hear what the basis of their objections are. We also have an officer recommendation for refusal here on the grounds stated. Against that backcloth, it's extremely difficult to come up with a motion that would result in this proposal going ahead in accordance with the community's wishes, as it would seem. Therefore, my question to Mr. Fogg is, does this committee have the ability to move for approval of this site? And if so, exactly what are the criteria that we would have to satisfy in order to be able to withstand any legal challenge by another party?
The convener has tried to assist me, for which I'm grateful, by saying it's easier for me to comment in response to an actual motion rather than the generality of your question. But nonetheless, you've asked it. And I do find it difficult to know how to respond for a variety of different reasons. You have the report before you, and you have a situation where the applicants are acknowledging that their proposal is contrary to the Statutory Development Plan. And there's a presumption in law that the provisions of the Development Plan will prevail. This application is contrary both to National Planning Framework 4, the retail policy in particular of that document. It's also contrary to the Local Development Plan 2 of 2019, which identifies the whole of the site for residential use alone. Weighing against that, there's clearly a community wish to have extended choice, to have the jobs that this will generate, and to provide some inward investment to this locality that we've heard could well benefit from that. I understand that. I have difficulty in seeing how those considerations and such other considerations that could be added would be of sufficient weight to justify departing from the two components of the Statutory Development Plan. But ultimately, it would be a decision for the court to take, having regard to the particular wording of the motion and the challenge that was made.
Just a quick follow-up, if I may. were the committee therefore not to come up with a motion and that the recommendation is approved, can you just confirm that the applicant then would be in a position to appeal that decision should it choose to do so?
Absolutely. The applicant would indeed have the ability to challenge the refusal before probably a reporter appointed to act on behalf of Scottish ministers.
Thank you.
Probably more likely than not to do so.
Thank you. Any further questions? No further questions. Can I ask for a motion? Councillor Frampton, you put A, but I believe it's a motion. Yes, thank you.
I move that we move the motion to approve the back application based as a departure from both NPF4 policy 28 and the residential zoning of LDP2. This application for a Lidl store in this site would be welcomed by many communities, both close to the proposed site as well as further afield. Examples being Bertha Park, Hunting Tower, Ruthven Field, Ammonbank, Methven, etc. This proposal fits with PKC's aims to have 20-minute neighbourhoods where everything they need can be purchased within 20 minutes of their home. The proposal will provide local employment for local people, which is needed. It will cut down car emissions in Perth City itself, given that most people, when they're going to get their weekly shops or whatnot, drive to supermarkets within Perth City to get their shopping. I don't believe a Lidl at this location would take businesses, as we have heard, from Perth City supermarkets. This is evidenced by Tesco having 3 outlets within Perth, Aldi having 2, and neither seem to suffer loss of business but thrive instead. This proposal simply offers more choice for the surrounding rural villages, etc., out with Perth itself, and therefore I support the application.
Thank you. Councillor Allen, you wish to second?
I do wish to second, yes. I believe that the proposal is acceptable in relation to development plan. It will provide a discount food store in the local area, which is accessible to all in the immediate area, communities especially of Letham, Tulloch, Bertha Park, Methven, Hunting Tower and Varalman. Proposal is in accordance with NPF 4 policy 15 on local living in a 20-minute neighbourhood. I think the importance of such an investment in the local area as well can do no harm. There are no objections whatsoever from consultees. It's a significant local support and it's a positive impact on a site that is currently not used. I definitely do second this proposal. Thank you.
Thank you. Can I ask if there's an amendment? Councillor Illingworth.
Yeah, I'd like to reluctantly propose that we accept the report from the officers. I suspect and that if we reject their papers, we will end up in court and may face the risk of quite a large expense. I completely accept the mover and the seconder's points on the value of this project, but I don't think we're going to get it through in the long term. Thank you.
Thank you. Do we have a Councillor Harvey? You're going to second that?
Yeah, I just did. Yeah, I'm happy to second without any further comment.
Thank you. Do you have any further amendment? Just give me a second, please. Okay, then, right, so. Just give me a wee second here. Okay, Councillor Frampton, do you wish to sum up? No. Councillor Illingworth? No. Do we have? Okay, I'll hand over to Mr. Fogg.
Thank you, convener. The motion before the committee this afternoon in respect to this application is advanced by Councillor Michelle Frampton, who has moved that the application be approved as a departure from the development plan, and in particular both NPF 4 Policy 28 and Local Development Plan 2 of 2019, for the reasons that she narrated, which I'm not proposing to read out again just now, but her motion was seconded by Councillor Allen. The amendment is advanced by Councillor Illingworth, who has moved that the application be refused in accordance with the recommendation in the strategic lead for economy development and planning, and his amendment is seconded by Councillor Harvey. I'll pass over to my colleague Ms Brown, who will go through the roll call vote.
Can I just stop there? Sorry.
Yeah, maybe just for the avoidance of doubt, I take it, Councillor Illingworth and Harvey, you are content that the reasons for refusal are restricted to the by the removal of the third reason, as explained this morning by Councillor Williamson, by Mr. Williamson.
I'm content.
Right. Sorry, before we go to the vote, I did get that round the wrong way. Can I ask members if they have any comments on the report first? No comments. Councillor Ian James.
Don't sound surprised, convener. I just think it's very sad that we're bound up by a national or an NPF 4 policy which is vague at best and contradictory at worst. Our officers have done a sterling job in trying to make a silk purse out of a pig's ear here, and you know we've got to put some common sense into this. We have so many applications coming forward for big developments. None of them come with any infrastructure to go with it, and here we are having the opportunity to put something in place for several housing developments. I think this is a bonus, convener, and I can't see why we should refuse it. Thank you.
Thank you. And just to say to you, Councillor James, and the committee, that I will be writing to the Planning Minister to express our concerns on that issue that you have just raised. Thank you.
Thanks, convener.
Councillor Braun.
Yeah, thanks, convener. We are all looking to encourage economic development. I think it's important that we do develop an area. This is an ideal site, I believe, for it. I find it very despondent to think that an organisation such as Tesco's, with its longevity, I won't say it's a national treasure, but its national status in this country, people do regard it as a high quality supermarket, that they are in fact running scared of a bit of competition. I find that very disheartening, and also I think it's disheartening that courts will stifle competition at the behest of a large retailer. I think that's wrong, but that's an opinion. But I find it very despondent that something like that would run scared of a bit of competition. As for NPF 4, it talks about 20-minute neighbourhoods, which is in principle is fine, but the core of that, of course, is the concept that we can't drive a car anywhere. And if we're going to stop every development simply because you've got to drive to get to it, then we might as well just shut up shop and go back and live in a cave again, because this is ridiculous. We can't live in that sort of world. And they quote the term sustainable transport, but my thoughts are that electric cars, hydrogen cars, hybrid cars, they are sustainable transport. So their argument starts to fall down already. So I will be supporting this, because I think as a committee, we should encourage wherever we can economic development. This is a massive development made by a well-known retailer. They've obviously done their calculations, their work to assess that there is a demand in this area for that sort of discount store, and I certainly will be supporting it. Thank you.
Thank you. Bailey McLaren.
Thank you. I won't go into the detail about the conversations around policies MPF4. Recognised site is zoned in LDP2 for housing, but this application allows housing still to be delivered on that site. And I hope, if everything comes to pass, that will still happen. It is a derelict site at the moment. We have an applicant here who is willing to invest in Perth, and in fact has come back with a stronger application, bring employment, but equally the residents within that 20-minute neighbourhood area will have an extended food choice, which is important. And that freedom of choice should be there. And yes, it's a larger retail opportunity, but that freedom of choice should exist for these people. And let's not forget that we have areas of deprivation within that 20-minute zone. And that is extremely important to remember. And so that offering is even more important to some of these people. So I will be supporting Councillor Frampton's amendment.
Councillor Harvey, I noticed you put in a comment. You can't comment because you've... Okay. Councillor Drysdale.
Thank you, convener. This is a difficult one, a really difficult one. And I place no criticism whatsoever on the officers before us today. They are doing their job very ably and very well in applying the rules, and as they see them. However, my view is, as an elected member, we have clearly heard the views of the local communities here. You have also seen, if I might say, the disrespect to the process by Tesco by seeking to object after the objecting after the deadline, and therefore their comments are not heard. I think that is reprehensible and regrettable. But having said all that I have said, I will be supporting Councillor Frampton, and I appreciate that may result in a situation where there is legal action taken by the objector singular. But I think it's the right thing to do. Thank you.
Thank you. No more comments, so I'll hand back to Mr. Fogg.
Thank you, convener. Immediately before we go to the roll call vote, as I'm reminded by Christian there, I wonder, Councillor Frampton and Councillor Allen, as this was a recommendation for a refusal, you don't have before you conditions that the officers would be recommending were the committee minded to approve. I wonder, therefore, as part of your motion to approve the application, you would allow us to read into it that in the event that your motion is successful, there'll be delegated authority to officers to go away and identify appropriate conditions that they would otherwise have commended to you had they been minded to approve it, to allow this to be appropriately brought forward with appropriate safeguards to protect the environment and residents, amenity, traffic and so forth, together also with the developer contribution that is referred to in accordance with our supplementary guidance.
Yeah, I'm happy for that.
Thank you, Jeff. Yeah, I was going to move this, but seconded Councillor Frampton, and I was basically going to say I move the application. Should it be approved with standard conditions? So yes, I agree. Thank you.
In which case, Convener, I don't think there's anything else outstanding, and I will now pass to Ms Brown to proceed with a roll call vote.
Thank you, members. In terms of Standing Order 21.5, we will now take a roll call vote. When your name is called, if you could advise if you're voting for the motion, which is to approve, or the amendment, which is to refuse. Councillor Keith Allen.
Motion.
Councillor Bob Braun.
Motion.
Councillor Dave Cuthbert.
Motion.
Councillor Eric Drysdale.
Motion.
Councillor Michelle Frampton.
Motion.
Councillor Ken Harvey.
Amendment.
Councillor David Illingworth.
Amendment.
Councillor Ian James.
Motion.
Councillor Ian Massey.
Motion.
Bailey Claire McLaren.
Motion.
Councillor Grant Stewart.
Motion.
We have 9 votes for the motion and 2 votes for the amendment. Therefore, the motion will carry.
Okay, thank you. Therefore means that planning permission is granted, subject to the conditions. I don't know how we say this. Something to the conditions.
Subject to appropriate conditions.
Appropriate conditions. That's the one. And developer contributions. Thank you. So we now move on to 523, which is a Section 42 application to vary conditions 1, 4 and 5, duration, acoustic, noise and deletion of condition 3, fence or permission of 22-00334/FLL, Crieff Hydro Hotel, Fen Tower Road, Crieff. And to introduce a report is Mr. Williamson.
Thank you very much, Convener. The next local application today relates to a proposal which some members may recall from consideration at the meeting of this committee from September 2022. The proposal, which was approved conditionally at that meeting, related to the formation of a clay pigeon shooting range, shelter building and earth bunds 1.3 kilometres northwest of the Crieff Hydro Hotel in its wider grounds towards the Hosh. In this instance, planning permission is sought for a variation to the following conditions. Number 1, which limited the permission to 22 September 2025. Condition 4, the need for acoustic insulation in the range building. Condition 5, the need for a noise impact assessment following necessary mitigation works. In addition, it's also sought to delete condition 3 in its entirety, which related to the provision of a 1.5 metre high acoustic fence. As outlined in paragraph 24 of the report, the application was the subject of 15 letters of objection, together with 1 letter of support. The objections in most part referred to noise pollution, the methodology for the noise impact assessment, impacts on access and biodiversity, and also being out of character with the area. Within paragraph 39 of the report, it outlines that the previous grant of planning permission was temporary to allow for an ongoing review of the situation. That remains to be considered a proportionate and appropriate route to take, and in this instance, a further 3-year period is considered reasonable. In respect of condition 3, an updated noise impact assessment was undertaken, and environmental health officers are satisfied with the associated methodology and conclusions. Therefore, condition 3 relating to noise attenuation fencing is no longer required. Turning to conditions 4 and 5, as outlined in paragraph 52 of the report, while not strictly necessary, the applicant still intends to carry out the shooting enclosure insulation. Therefore, a rewording is required. And similarly, with the submission of the updated noise impact assessment and demonstration that noise levels can be achieved, the condition can be deleted. All other relevant conditions would be kept on the decision as outlined in the report. I'll now take members through a short presentation to detail the proposals further. First, we have an aerial image showing the location north of Crieff, east of Hosh and southwest of the Monee estate. The red line boundary shown on this slide illustrates the connection point of the site with Ferntower Road before leading up past the 9-hole golf course to a plateau in a relatively rural location. Next slide, please. Next image is an OS plan merely outlining the application site boundary in relation to the wider ownership of the applicant outlined in blue. It also shows more detail of the site layout with the shelter building located to the north, C-shaped earthburn to the northwest and south. The plan also illustrates the topography in the area. Next slide, please. Here we see a repeated aerial plan showing the wider area again, and I'll now show members a series of photographs for context. Here we can see the initial track leading to the clay pigeon shooting range on the left, while on the right is a view looking northwards. This demonstrates how the shooting range is set into the landscape beside the existing bunding. Next slide, please. Next, we see the eastern gable of the shooting range with the bunding and existing trees located beyond. On the right is a view southwestwards showing the existing bunding. Next slide, please. This final image shows a view from the southeast looking over the shooting range and showing the associated landscape in the area. Next slide, please. Thank you, convener. That now concludes my presentation and I leave you with the site plan.
Thank you. We do have a deputation on this, so I'll ask the vice convener to hand over to the vice convener for the deputation's procedures. Thank you.
Thank you, convener. Can I call on Mr. Crichton, objector? Thank you for your patience, Mr. Crichton. I'm sure you're aware you've got 5 minutes for your deputation. I'll start the clock when you're ready, and I'll give you a wee prompt when there's about a minute to go. So in your own time.
Thank you for the opportunity to speak today. My name's David Crichton and I'm here both as a local resident and business owner and on behalf of the Hosh Residents Association. This is the third planning application submitted by Crieff Hydro in 5 years for a shooting range. 3 years ago, permission was granted for a trial period subject to several conditions. These conditions weren't met, meaning the facility never operated. Now, the applicant seeks to change those conditions. This remains a contentious issue within the community. The percussive nature of shotgun noise is widely recognised as disruptive, which is why the Chartered Institute of Environmental Health advises a buffer zone of 1.5 kilometres in front of firing and 1 kilometre behind. In this case, the nearest properties are 650, 750, 850 metres from the site, well within those recommended distances. Furthermore, the NOC is an established public amenity space. At the previous hearing, the committee raised concerns about boundaries and proximity to footpaths. Despite 3 previous objections of ours highlighting boundary inaccuracies, the applicant only recently corrected their site map, confirming the shooting hut is just 12 metres from our boundary. And this is their corrected map, which is different to what one of your officers has just put on the screen a moment ago. For us, there are the following key planning considerations. Firstly, noise management and mitigation. We welcome the applicant's proposal to use low noise cartridges and shotgun suppressors, silencers, and their use, or the use of the latter, is integral to this renewed application. However, these reduce but do not eliminate noise disturbance. The original condition required noise levels to remain below 55 decibels and plus 5 decibels of background noise, a target that remains challenging given variable climatic conditions. The report says 45 versus 40, 51 versus 46. It's very tight. Furthermore, the site measurement methodology is also key, and issues surrounding how far they are from affected properties. 2, physical barriers and landscape impact. We acknowledge that the additional acoustic fence is no longer required or feasible. However, we would request that the bund at the rear side of the shooting hut is raised to its original specified height of 1 metre above the roof, as their consultant stated in 2002, combined with the interior insulation as agreed. 3, consistency in noise reduction measures. While the applicant has proposed using low noise cartridges and silencers, our past experience raises concerns about enforcement. When the shoot was previously operating, they did use lower noise cartridges, but admitted switching to louder ones when stocks ran out. This demonstrates without strict conditions, noise levels could fluctuate unpredictably. To prevent this, we asked the committee to ensure the use of low noise cartridges and silencers is an enforceable condition, one that can't be waived due to cost or supply chain issues. 4, safeguarding the future amenity. The existing condition allows for a review of operations in the event of justifiable noise complaints. This is a reasonable safeguard and should remain. Crucially, we support the retention of a 3-year time limit, allowing the community and the planning authority to assess the long-term real-world impact before any permission is granted. In conclusion, the noise consultant called it subjectively audible. As individuals, we all object strongly, full stop, because we've experienced distressed toddlers, distressed dogs, distressed horses. It makes it hard to live life well, knowing that this could be happening in the background. However, as a community, we are practical and we're respectful of the data. We know the committee previously approved the application with conditions to balance business interests with community well-being. And in that spirit, we urge the committee to retain a 3-year time limit to protect local amenity, ensure the noise management conditions are enforceable and accurately monitored, and require the bund to be reinstated to its original specified height for additional protection. Its decision is not just about the immediate impacts and numbers, but about setting a precedent in this for responsible planning and community relations. Thank you.
Thank you, Mr. Crichton. You're going to take questions from members. Councillor Allen.
Mr. Crichton, thank you for your deputation there. Can I just clarify, if those conditions that you've just said were met, you'd be quite happy?
We are respectful of the committee's decision to balance business interests and community well-being. It will be noticeable. It will be subjectively audible. Your role here is to find a compromise that you feel suits every resident. Our view is we would much prefer that it wasn't occurring at all, but you previously decided to allow it to proceed with those conditions, and you've also given us the opportunity in both immediately to make justifiable noise complaints and to review it in 3 years' time.
Councillor Harvey.
Oh, sorry. Shows you how loud a voice I have. I've forgotten what my question was now. Oh yeah, you implied that you were concerned that some of the rules and conditions would not be enforced properly. Was that your contention when you made your comments?
Yes, some aspects to do with building are very clear. Are one shot or one item things you can see. The use of low noise cartridges and shotgun silencers at all times and how that can be enforced is important. The difference within and without those items is noticeable, significantly noticeable. And we are concerned that for any number of reasons, stocks, supply, safety concerns, people wanting to do something different, that might not always be the case. So we ask that you write very clearly in your condition that low noise cartridges and shotgun silencers must be used at all times, or else.
Mr. Crichton, there's no further questions. You're free to go. Members, we have Mr. Denham, who's acting on behalf of the agent, who is willing to take questions. So if you have any questions, please put them in the chat. Bailey McLaren, are you going to ask a question? Mr. Denham, would you like to come up to the lectern? Bailey McLaren.
Thank you. Good afternoon, Mr. Denham. Mr. Crichton has just expressed deep concern about consistency of management of use of cartridges and machinery in regard to noise proliferation. Has that been fully taken on board by the applicant, and are they fully committed to adhering to that, or do, you know, it is?
Can I just say absolutely, if it's a condition of the planning, they're a respectable, responsible client, and they will act accordingly. And of course, if they don't, I'm sure the planners can take action. But I mean, to suspect they won't follow the rules. And just a bit of background, they came up with the hush power guns, which are much quieter. They have met the standards, and this is the Hydro who've generated all that. Objectors have been consulted all the way through, invited to sound testings, etc. I think they've behaved very responsibly, and I think they'll continue to behave very responsibly if this is approved.
I thank you, and thank you for that extra bit of information. Thank you.
Convener Massey.
Thank you. You've just heard Mr. Crichton's deputation, and at the end he said he had some can't remember the name. Concerns, yes. Well, he wanted to put some conditions. That's the word. Well done, Billy McLaren. That word just went for me. Some conditions. Would the hotel be willing to accept these conditions?
I think yes. I mean, as per the report of handling, I think these are we've asked for alterations to the conditions, the previous ones, and mainly this is generated by a new type of the gun, the hush power, and the cartridges. So that's really, I think, the fundamental big concern of people was the noise. So I think that's been addressed. The conditions. Now the other thing is that in the sound report, the sound people say they don't need to upgrade the. And I think that's been accepted here as well. They don't need to upgrade the acoustic protection of the hut that they're shooting from. The Hydro still intend to do that anyway, even though it's not required, to improve things even slightly more.
Councillor Allen.
Thank you, Vice Convener. I think Convener Massey just asked one of my questions, but I'll ask a different one. One of the concerns by the resident, Mr. Crichton, was that when you run out of cartridges, you go into normal ones, or what would be the situation going forward if that was the case? And as an alternative, if I came with my own gun, would I be allowed to use it?
No, I don't think you would be allowed to use your own gun. because it's not this hush power gun. And well, I mean, all that I can say as an agent, that I'm absolutely 100% sure that Hydro will only fire the appropriate cartridges. And as I say, if somebody's away and somebody else arrives in their car and does it, then I'm sure it'll be reported immediately, and the council can take action. And the Hydro themselves, if they'd heard that happened, are going to take action. So, and I think we could get them to confirm that. I mean, it's I think we've got to respect that they will do what's in the terms of the planning.
Yeah, one of the concerns was that previously, when they ran out of shotgun cartridges, they used the noisier ones. I think we should make it a condition that they don't have the noisier ones, full stop.
I think they'd be very happy to adhere to that condition.
Mr. Denham, there's no further questions. You're free to go. Convener, there's no further deputations, so I'll hand back to yourself.
Thank you. Yes, my question is, the conditions that were put forward by Mr. Crichton, are they all included in the report? If so, can you confirm it?
Certainly, obviously, in essence, we have sought to review the permission that had been granted previously. We've looked at the conditions that the applicant has sought to amend as part of the process. At the same time, we've reviewed all the ones that had been applied previously. But in this instance, yes, as far as I'm concerned, it does address the use of low noise cartridges, the use of the silencers, the opportunity for noise complaints to be investigated where they're found to be reasonable noise complaints, etc. It sets out the times for operation, etc. So yes.
Can you also confirm, is the bund to be raised back up to the height? I mean, I think that was something he requested.
It was certainly a desire of Mr. Crichton, but the bund is not to be raised as part of these proposals.
Thank you. Vice Convener Stewart.
Thank you, Convener. I didn't have time to withdraw my question because Councillor Cuthbert asked it. Thank you.
Thank you. Do we have any further questions? No further questions? No. Can I ask for a motion then? Councillor Braun.
Yes, very simply, can we move to the paper as is written with the conditions?
I'm honestly, we were seriously. Sorry, I do apologise. Does committee have questions? No, comments. Councillor Allen.
Just for the avoidance of any doubt, I don't have a gun, thank you.
Councillor James.
It was only to second Councillor Braun's motion, Convener.
Okay, thank you very much. Can I ask if there's an amendment? No amendment. Therefore, planning permission is granted, subject to the conditions in the report of handling. Okay, we now move on to the last application. Councillor Braun, if you could come back in 2.5 hours once we've decided. Okay, this is 524. It's the change of use of and alterations of a post office to form extension to dwelling house Bridge of Cally Post Office, Bridge of Cally, Blair Gowrie, and to introduce the report is Mr. Williamson.
Thank you, convener. The final local application on the agenda today relates to an application submitted by an elected member, in this case Councillor Bob Braun. In line with the Council's scheme of governance, this application is required to be determined by the Planning and Placemaking Committee. In this instance, planning permission is sought for the change of use and alteration of the existing post office at Bridge of Cally to be integrated into the wider attached dwelling house. It attracted no letters of representation and otherwise would have been approved under delegated powers were it not to be the submission of a councillor. While the loss of any local shops and community facility is regrettable, adequate justification has been provided in this instance to outline the reasoning behind the closure. With post office facilities being available in Blair Gowrie, there is still provision locally within a reasonable travel distance, and given the scale of Bridge of Cally, it's appreciated that it could be difficult to sustain the existing business. In respect to the physical alterations, given that the post office and shop element already form part of the wider structure, for all intents and purposes, it already appears as if it's part of the original structure, and therefore its incorporation into the dwelling is acceptable. I'll now take members through a short presentation to detail the proposals further. Here we can see the location of the site with the small settlement of Bridge of Cally. Next slide, please. Here we can see the location plan, which shows the positioning of the existing building beside the River Ardle and also at the junction of the A93 and A924. The building also lies a short distance north of the Bridge of Cally Hotel, with a number of residential properties located further to the north. Next slide, please. Here we can see the proposed site plan, which shows the extent of the property and its associated garden ground, and also the wider land in the control of the applicant. Next slide, please. Here we can see the proposed elevations. The only external change is the blocking up of the existing door to what is currently the post office in order to become a window. Next slide, please. Here we can see the proposed floor plans, which show the former post office becoming an extended sitting room. And I will now show members a series of photographs for context. Here we can see a street view imagery of the site at the junction of the A93 and A924, with the Bridge of Cally Hotel visible in the top photo, while at the bottom is the view westward showing the A924, which leads to the Bridge of Cally Holiday Park and Poultry Farm. Next slide, please. Next, we see the entrance to the post office on the left and the view from the bridge over the River Ardle on the right. Next slide, please. And these final images show the site from the west and also the existing dwelling entrance from the A924 and also the rear elevation with views down to the River Ardle below. Next slide, please. Thank you, convener. That now concludes my presentation.
Thank you, Mr. Williamson. Can I ask if the committee have any questions for officers? No questions. Can I ask for a motion? Councillor Cuthbert.
Yeah, thank you, convener. It's been a long day, so I just thought I'd get in quickly. I drove past the site at the weekend. I can't see any reason why this shouldn't be approved, so I'm moving the paper as it stands.
Thank you. Councillor Stewart, you're seconding.
Happy to second, and I agree with Councillor Cuthbert and the recommendations of the officers.
Can I ask, is there an amendment? No amendment. Can I ask if the committee have any comments on the report? No comments. Okay. Therefore, planning permission is granted. Thank you. That's the last item of business today, so thank you very much for your time. And those for watching, apologies for getting a few things wrong today. Thank you.